Good morning. I'm Misha Janice. Thanks for joining me. We are in the middle of the Sarah Boone Richardson hearing. This is regarding discovery violations that the state alleges um, the defense made. So we are going to go right over to that right now. They're in the middle of it. Oh,
Be removed. Does everyone understand? Thank you.
that's the
You may
first
proceed.
court admonition
And I realize
to
that I've
everybody in
only
the
had a
courtroom.
limited
So
amount
your
of
cell
time
phone went off.
to review the 119 pages that came in yesterday. Um, and again, it's more difficult to review those because
Morning.
it's not in a PDF where I can word search it and do any of the things that are afforded to us with modern technology. It came in as 119 separate JPEGs. They're not in order. So for instance, when I'm trying to look for page 43 of those 111 records out of the 119 pages, it's not in order. And I've done my absolute best to try and see if this page, which is 68.
Yes. And referring to 68 of the 81 that was
Yes,
entered
sir.
as one, correct?
Yes, sir.
Thank
It
you.
is sub-labeled within these records as page 2 of 14. And it appears to be a part of her visit on January 23rd, 2018. And in the social history provided, it says alcohol use denies, tobacco use denies, and the other part isn't relevant. And I just haven't been able to find that. And so I'm asking for the leeway to continue to try and search for that particular page out of the 119 so that I may ask that out of the doctrine of completeness and fairness that it be included. I'm just at this point, I've not been able to find anything in the records that says that, and I'm limited in my abilities to cheat with technology and put it, if there's a 119 page PDF and you make it word searchable, you just put in the magic word and it helps the attorney greatly. So that's why there's this confusion, and that's part of why I had to raise this issue. Was just at my first glance of those pages yesterday, I knew that something seemed off compared to what was previously provided.
Okay. Any response?
It has a heading, Your Honor. I'm not familiar with that heading in the documents that I was reviewing. I'll look for it again and I'll provide.
Okay. I appreciate y'all working together on that. So here's what we're going to do.
If I may.
Yes.
We had told the state that we would bring in a printed copy, not the PDF, this morning. But Federal Express, which is the block away, for whatever reason, the road was being constructed. So they
What?
closed. So we were there at 8 o'clock to get the copy to the state we had promised, but we will bring one at lunch to hand the state.
Okay. Appreciate it. All right. Any other argument with regard to the Richardson issue? Anything further, Mr. Beck? Okay. With regard to, let me conclude the Richardson analysis first. All right. Thank you both for your positions and your arguments. The court has, as a matter of law, the court needs to determine whether the defendant's violation was inadvertent or willful. Court finds that based on the positions provided by the defense that the disclosure was inadvertent, but I do find that the violation had some level of substantiality to it. But due to the state's review and the defense compliance with the court's order yesterday as to culling down to the pages that we've identified, the court finds that the violation had a limited ability on the state's ability to prepare for trial due to the lack of objections to the majority of the documents, with the exception of page 48 and 26, which are sought to be included. For those reasons, I find that the prejudicial effect of the substantial disclosure is limited, and I'm not going to order the defense, not going to prohibit the defense from proceeding forward on moving these items into evidence. However, I do want to address the 403 rule of completeness issue with regard to pages, 26 and 49 as, 26 and 48 as sought by the state. No objection, Mr. Beck. All right, thank you. So The state's request is granted. Pages 26 and 48 will be included in any evidentiary documents that sought to be moved into evidence with regard to this January 23, 2018 incident, as provided in the 119 pages of item 2 of the defendant's fifth amended reciprocal discovery exhibit list. I will not foreclose the state regarding page 68 of the 81 pages. If they are able to find that additional document, we can address any argument at that time as to why that should be included. Anything further, state, before we bring in our jury?
Judge, the defense team has indicated to me that they intend on using demonstrative aids during opening statement. The ones that I have seen include jury instructions that may not be given and may not be given in the way that the court gives, and photographs that could be coming into evidence. I identified at least one that I don't recognize as something they sought to be seeking into evidence, perhaps two. So I believe we should have a discussion about each and every one of those. They should each be marked for the record purposes by letter so that we can refer to them and make a record. I believe it's in the court's discretion, even though I rarely see it exercised in this way in this circuit, to allow the respective parties to refer to actual exhibits during opening statements. I would urge the court not to allow that. They're going to see them soon enough, but particularly with what they are seeking to introduce, given the motion in limine ruling that the court has already issued, that at this point in time, the latest proffer with the defendant's testimony is not amounting to an overt act that will result in a self-defense instruction, that will result in prior instances of violence coming in, that it would be extremely prejudicial, dangerous, and to use Mr. Cacciatore's analogy, very impossible to put that toothpaste back in the tube if we amplify our opening statements, which may or may not come to fruition when we start talking about these past instances and battered spouse syndrome. It would be greatly amplified if they're actually seeing exhibits of the defendant's past injuries that she's attributing to the decedent. So I'm asking for us to discuss that.
Response before we go through each photo.
Judge.
Go to the microphone, Owens.
Defense is self-defense. Sarah's going to testify that she was defending herself. We believe the court's going to rule we're entitled to put on a case involving self-defense. And under the instruction for justifiable use of non-deadly force and the justifiable use of deadly force,
I'm not discussing the jury instructions at this time.
there are
Go to the microphone. Oh,
Here's my concern.
this is
Why are we addressing law in opening statement?
Well, I agree with the state attorney. I did follow up on the justifiable non-deadly force.
That does not answer my question.
Oh, it's going to be a long day, you guys.
Okay. No, I can see it, sir.
And the other one is the reasonable doubt, either possible doubt, speculative, imaginary, forced doubt.
What's your position with regard to those two, Mr. J?
Judge, opening statements, we should be discussing what we anticipate to come into the trial, and that's going to be enough of a minefield. It really shouldn't be about the law. We'll both have an opportunity to use the actual jury instructions, which we have not decided upon. We will have the opportunity to use that overhead or any means that we want at the end of the trial during our closings to put up what is actually decided to be the law after the case has been presented. So it's our position that we shouldn't be using demonstrative aids with portions of jury instructions we're going to have that opportunity to argue how the law applies to the facts at the end, and we will have the correct version. And if the court is following the tendency that I've seen in this circuit recently, we may, in fact, read 3/4 of the jury instructions to them before we even begin our closing remarks. I think it's premature and problematic to be doing that at this time, and it's not the role of opening remarks.
Any other response?
I've been doing this 35 years. I've had these boards. I've used these boards at opening statements I don't know how many times. I've said that I would waive introducing the one specific to self-defense, but reasonable doubt is an instruction you gave to the jury when we got started. And then this weighing the evidence is a standard jury instruction that applies in every case.
Are those the standard? Is that the language of the standard instruction?
I have not had the opportunity this morning to pull up the Florida Standard Criminal Jury Instructions off the Supreme Court website due to dealing with motions in limine, trying to prepare my opening statement, and doing all the things that I should be doing on.
So we don't know if what Owens put on the
I did notice that I
board,
did not believe the
if it's
reasonable
the
doubt instruction
actual
was complete just from memory, and I know that's not the complete weighing the evidence instruction either. It's an entire page of instructions for each of those.
Can I see the reasonable doubt instruction, please? Well, here's the first problem.
That's so much.
That's the wrong instruction.
Huh?
Florida Supreme Court revised 3.7 earlier this year. That is not
Womp womp.
the appropriate definition of reasonable doubt. It is not what was read to the jury
How
during jury
embarrassing.
selection. 3.7 now
Ugh.
reads, proof beyond a reasonable doubt, and it does not mean proof beyond all doubt. Reasonable doubt is not a mere possible, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there's not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable.
Wow, y'all.
That does not track the standard jury instruction. For those reasons, I'm not going to allow it.
Judge, I'll have it redone.
As long as it, I mean, we're still in the process of working through. The 3.7 instruction speaks for itself. I won't preclude you from using enlargements in closing, but for the purposes of opening, because it doesn't track the 3.7 instruction, I'm not going to allow it.
This is an excerpt from.
Good morning, Marie James. They are absolutely not public defenders. They are not. They're the attorneys that responded. Actually, this attorney, this gentleman here, Mr. Owens, responded to Sarah Boone's help wanted ad, her handwritten jailmaid help wanted ad. That's how he came into the picture. Then he brought along some other attorneys with him. They are not public defenders. Good question. So what's happening, James Owen, defense counsel, Sarah Boone's attorney, is trying to show
That seems to be the
jury.
standard 3.9 instructions, or at least portions of it. Response?
Again, since it's not all of it, it's misleading. It's highlighting something about the law when we're just talking about opening
It wasn't a
remarks.
joke.
Opening remarks. 6 through 10 are optional. We haven't decided which out of the optional instructions, 6 through 10, we're going to use in this case because we have not heard the evidence yet. So I just think it's inappropriate to be delving into pieces and portions of jury instructions before we get the evidence. What we should be doing is explaining to the jury what we believe the facts are going to show and the inferences that they can draw from them, and argue the law later.
Last bite at the apple, sir.
Judge, they've got to have some guidance to the law. You know, that in many ways, we do it where we give them the law at the very end, you know, and I understand the reason for that, depending on the evidence that comes in, but there's standard instructions that are going to apply throughout. And this is just giving them an idea of what their role is in considering the credibility of witnesses. I think it's appropriate. It's a brief statement of a standard instruction that comes in on every case.
Let me move to the photographs before I address the 3.9 issue.
Good morning, Charlie.
I think for the record, we should mark them.
Okay.
Oh, can we see the photos?
Do you want them marked? You want them marked by Madam Clerk, correct? Okay, so let's approach with that first photograph, please. Madam Clerk, yes.
Unless they're gruesome or autopsy photos, then I think I might have to pause or something. Well, thanks for being here, you guys. Right now, the state and the defense are going through what they want to be able to show the jury in the opening statements. So defense is trying to, provide big blowups of the law, which is not really the purpose of opening statements, the state argues. Rather, it's to tell the jury what they should be expecting to hear from the evidence, what the evidence will show. So the state is arguing, leave the law and all the legal grounds for reasonable doubt or self-defense, leave that until the end and just tell them what your evidence will show during the trial. It looks like the defense is also trying to get in pictures, blown up large pictures of, I'm not sure what, but the judge is going to see those pictures and he's going to make a determination pretty shortly here. After this, they should be getting started with opening statements, fingers crossed. Good morning, Lou. Happy Friday. Happy Friday, everybody. We're here. We are here and we're getting started with this case, finally. So what we had earlier this morning, before this portion of the hearing, was the Richardson hearing, and the state requested a Richardson hearing yesterday. And this morning they detailed all the, what they say are discovery violations, intentional discovery violations by the defense counsel. So the state went through the fact that there's skipped pages, in the mess of discovery that defense provided them. There's incomplete documents, there's misleading documents, and documents that don't provide full context. For example, he said something about there were documents, medical documents of Sarah's showing that she was tested for certain things. I'm not sure if they were blood tests or not, but there are no results, no documents to show results of those tests. So the judge in hearing a Richardson hearing has to determine whether or not the actions by the defense were inadvertent or willful. So the judge heard both sides and he ruled that the disclosure was inadvertent. So they didn't intentionally maliciously do these things, skip pages and provide pages upside down, crossways instead of up and down, PNGs instead of PDFs, but that the disclosures were substantial. But based on the defense's complying with some orders that he gave to them yesterday, including providing certain documents by 9 a.m. this morning, which defense was able to do, the state has not been prejudiced too much. Prejudicial. The judge also said that the prejudicial effect of the substantial disclosure is limited, and he is not going to prohibit the defense from moving certain of these documents into evidence. There still was a small caveat because there are certain pages that the state still does not have that I think the defense is supposed to look into getting, supposed to track down and see if you can find them. So it's open ended, I think, to a certain degree. So that was the Richardson hearing. Richardson hearing is to discuss discovery violations. And now we are just going through whether or not photo blowups can be shown by the defense in their opening statements, which should be getting started shortly this morning. So thanks for being here, you guys. I know I didn't give you very much notice, but YOLO, you know? Thanks for being here. Grab your snacks, grab your coffee, your tea, your water. I have my coffee here, I have my water here. I'm set, I'm ready to go. I don't have any snacks, much like Sarah, who also does not have any snacks. The judge ordered yesterday she's not to be given snacks, anything more than any other defendant should get. So I hear Owen's defense counsel speaking now, but of course he's not at the mic, so I don't know what he's saying. Hopefully the judge repeats it.
Next photo.
Oh, he's going through each photo, and the camera people on crime are not showing the photos, so they're probably not safe for work photos. They probably will not be shown. Hi, Jaidag. 1218. Hello from Lauderhill. Lauderhill. You guys, why am I thinking of Milk Duds right now? Oh my goodness. Close up of Sarah Boone's face where George Torres did something, probably hit her. Close up of Sarah Boone after she was kicked in the head by George Torres. Phones from typing.
Any other further argument with regard to the use of those items pre-marked as A through I in opening statement? Mr. Owens?
It seems like a lot of the photos
Did you
were
send it,
from
sir?
Sarah Boone's phone, and they show injuries to her body.
I have not
She
received
says
it.
were made from George Torres. What do I think of Sarah turning down the plea? She's a hot mess. Worst mistake, worst move ever. It's not going to go well for her. It really will not. She was not acting in her own best interest.
Does the
But she
state see a
probably
copy
couldn't
of it?
see.
I'm familiar with the case law. I did receive the email. I'm not sure if it indicated who all was copied on it. A separate one. I'll check.
Ooh, I love a good concession stand. Maybe some kettle corn,
Just
popcorn. What else?
And provided Alsager v. State, 326 7th 3rd, 656, Florida Supreme Court, 2021. Low v. State, 259 7th 3rd, 23, Florida Supreme Court, 2018.
Snickers,
Yes, sir.
ices.
Judge, the court has discretion to allow demonstrative aids. If you look at one or both of those, there was a state wanted to introduce a dummy they were using in a homicide case, which the court allowed. Other cases have allowed photographs and demonstrative aids to be used in opening statements. In the Alcaguer case, which is the 2021 case, trial court acted within its discretion in preventing state's use of a map as a demonstrative aid during the guilt phase rebuttal closing argument in a capital murder trial, where evidence visually demonstrated on the map was not without support in the record. That was actually an exhibit that wasn't record. The 2018 case, Supreme Court of Florida, again, the trial court acted within its discretion in allowing a demonstrative exhibit. In that case, it was a murder prosecution. Trial court acted within its discretion in allowing the state to use a mannequin in a demonstrative aid in order to show the position of the gun in relation to the victim's body. The mannequin was used to set out the circumstances of the crime and to attempt to establish aggravation. The mannequin was used to demonstrate the location of the gunshot wounds, the angle of the impact against the skin, the incapacitating nature of each gunshot wound. Advising of the trajectories were anatomical, not spatial, and had a small degree of error where only was slight difference between the victim's size and the mannequin's dimensions. There was nothing to suggest the mannequin was altered to resemble the victim. The court allowed, again, the court's discretion. As you know, we're claiming self-defense, and part of that instruction we're entitled to allege prior instances of difficulties and prior acts of violence so that the defendant who asserts self-defense, their state of mind is
Where'd he go?
exhibits will be introduced in evidence. They're demonstrative aids to aid the jury in understanding the circumstances surrounding that relationship and the actions that Sarah took and the reasonableness of those actions in light of their history.
Thank you. Any response, State?
Yes.
Yes, sir.
Judge, the standard is
Good morning, NCA
it is
Bets.
at your discretion, and you will
No,
only be
they have not.
reversed if you abuse your discretion in this regard. The state is urging you just flat out, as a matter of principle, to not allow
soon,
the
though.
parties to go into the exhibits during opening statements. They're going to be seeing the actual exhibits in the very, very near future. I mean, we can do this. We can play the videos. We can show gruesome autopsy photographs on the big screen as well during opening statements, but those things are all coming. So we're just asking you first in general, let's not extend the opening statements in that regard any more than necessary.
For real.
Now, our specific objections are this. With A, which is beneath everything now, but the bloody ear from the prior incident, I believe that is from a body-worn camera, and I think he indicated as much. It was not from her phone. If we get to that point where we know that this piece of evidence is coming in, that would be one thing. But right now, the law of the case is they cannot put on any evidence of prior instances of violence, any reputation evidence regarding the victim, or go into battered spouse syndrome in the evidence until self-defense has been established, and that self-defense must be established by the testimony, and in this particular case, it has to come from the defendant, of an overt act taken by the decedent, which resulted in an imminent threat of great bodily harm or death. And we have had that litigation. We have provided the court the most recent testimony regarding the defendant's most recent statements from the two doctors, and it doesn't exist at this time. So it's one thing for the parties to go into things in opening statements that don't end up coming into evidence. And when the defendant does that, well, under King versus State, the state gets to point out, look, they made these promises in opening statements and they didn't come to fruition. So you need to disregard everything that you heard that was going to happen in trial that didn't. But the problem, particularly for the state side, is we don't get to appeal. So if we go through opening statements and we have the jurors not only exposed to our words about things that may or may not be coming into evidence, but exposed to 1,000 words per picture, if a picture is worth 1,000 words, that amplifies the error. And it's an error the state has no remedy to fix. So we're asking for A, which would absolutely come into evidence. If we get this overt act testimony, which has not occurred yet, from the defendant, then certainly this is A would come in some of the other letters. And there's nothing wrong with them blowing it up like that. In fact, the state has it on their exhibit and will be showing it on the screen as well. There's not, a lot of dispute over whether that will come in if we meet that standard of an imminent act or overt threat of an imminent act of danger. B, I'm not sure B was on their list of items that they sought to use from the phone. We would argue a picture of her with her dogs on her porch doesn't have any relevance. I don't expect that to be coming into trial, so we're objecting on that separate.
That was one of the pictures?
And then returning back to C, D,
What?
E, F, G, H, I. State is all aware of those photographs. We are prepared to introduce them ourselves through the digital evidence. There's no hiding those things. If we meet the threshold for this sort of evidence coming in.
Could you identify those for me? I'm trying to keep notes contemporaneously.
Yes. C.
It was C through I included?
Yes.
Thank you.
B is the only one that is not a photograph of prior violence. I don't know, it wasn't on their list of things that they sought to introduce, and I don't know what the relevance would be of her just sitting there on her porch.
So all the photos blown up
But A and then
that they
C
want to
through
show
I.
in opening
Judge,
statement are
absolutely, at the end of the
pictures of
trial,
Sarah Boone,
great. Blow them up, use them as much as you
except
want.
for
but
one photo of
in
her
this
on
particular
the porch with the
case,
dogs.
with the rulings that the court has already made about this, based on the state's motion in limine, it is very dangerous to allow them to do this when we are not expecting it to be admitted into evidence based on the current state of the defendant's testimony.
Thank you.
Thank you.
Mr. Owens, if you could address Exhibit B, was pre-marked as B.
But Judge, you've already ruled that these things come in. Remember that prior
No, what I
ruling?
ruled is that you were able to discuss them. You address them in opening. Photographs
Not
are a
show
totally
them.
different kitty.
I said nothing about battered spouse syndrome. I said self-defense. These exhibits come in under self-defense. In arguing these, I've said nothing about battered spouse. I'm talking about self-defense.
I understand.
And prior difficulties, prior acts of violence
Mm-mm.
is a standard instruction.
But the overt act requirement remains. I mean, we've reviewed Holland and read it multiple times.
In good faith, with discussions with my clients, we believe there is going to be evidence of an overt act.
Okay, well, that has to come first.
That she was facing imminent threat, and she reacted based on that claim.
Understood. Your response to Exhibit B.
Look at the-
It's her on the back porch with the two dogs.
Judge, not only did he abuse, George Torres abused.
That's not the issue. The issue is that the state represented that it was not part of your exhibit list.
I believe it is part of the exhibit list. We got this from the state. They sent over a bunch of pictures of flowers or paintings that they want to introduce, that they've listed as exhibits. I thought for sure we put this on there, but the relevance of it is not only did he abuse Sarah Boone, George Torres, he abused
Don't
the
say-
dogs.
Oh my
He was
gosh.
threatened to abuse the dogs, to control Sarah Boone.
Have we heard this before, you guys? I haven't heard this before,
Okay.
that George
Thank you.
abused the dogs. I don't see how a picture of
All right.
Sarah on the back porch with the dogs
The court's
shows.
prepared to rule at this point in
Shows
time.
that.
Thank you both for your presentations
That's
and your
wild,
argument.
Val.
The court's had the opportunity to what was pre-marked as A through I inclusive. First, with regard to the portion of the 3.9 instruction, purposes of opening statement is to set the table of what the issues are, what the parties believe the facts and evidence will show. It is not a proper time to be discussing law or elements of law, and that is an element of law that will be instructed to the jury at the end of the case. So the court's going to exercise its discretion for those reasons and prohibit you from using the portion of the 3.9 instruction in opening statement. You could talk about, this is a job that you're going to have, but I'm not going to allow you to read portions of the instruction for those reasons at this time. With regard to what was pre-marked as A through I, the Holland case is clear. Before a defendant may introduce evidence of the victim's character, he must first show that there was an overt act by the victim at or about the time of the incident that reasonably indicated a need for self-defense. I understand your good faith belief. I take no position on whether or not you're going to make it or not. That's something that you're going to have to establish. But the concern is that the photographs, some of them are graphic in nature. The lacerations, the sutures, the bruising, facial wounds with bleeding may have such a impact such that the toothpaste cannot be placed back into the tube, assuming that overt act hurdle is not met.
Paste back
The
into the
court,
tube.
again, takes no position on whether or not you're going to be able to meet it because I haven't heard the evidence and testimony. So court's going to exercise its discretion for those reasons. You can talk about it. You can talk about it that she was a victim. You can talk about specific some incidences may have happened, but I'm not going to allow the photographs at this point in time for those reasons, for your utilization of them in opening statements. Any questions or clarifications with regards to the court's ruling? State.
No, Your Honor.
Defense.
No, sir.
All right. Are we
Yeah.
prepared to bring in
You're
our
right,
jury
Frederick.
at this time?
Yes.
You're right, you're right.
They've been waiting for an hour and 20 minutes, Counselor.
We intend
Oh,
to play the 2-minute Suitcase video to the jury in opening statement.
sure.
Hey,
It's terrible for your client.
Again, I'm asking you to urge your discretion. They're going to hear it in the next 2 days of court. It's within your discretion whether we're going to start using exhibits during opening statement.
what's the other issue, sir?
I need to approach the bench.
Okay. With regard to the video, I'm not going to allow proposed exhibits to be used in opening statements. It's good for the goose is good for the gander. If not going to allow your photographs, not going to allow the state to do anything. You could orally talk about what you believe the evidence and testimony is going to show, but the actual evidence is going to have to be presented here through witnesses or through demonstration and publication after that evidence is admitted. Y'all can approach.
While we approach,
fair.
can somebody from their team start dismantling?
Please, I would appreciate it. Thank you.
Not you, Mr. Owens. You need to approach. Oh, you guys. Wow, things are not going well for Sarah yet this morning, as expected. I mean, is anybody surprised? The judge is being extremely fair, though, in my opinion. He just ruled that the evidence is just not going to be able to be shown in opening statements. The defense wanted to show pictures of Sarah with her face beat, multiple pictures, A through I. How many is that? A, B, C, D, E, F, G, H, I. Like 9 pictures. And also one picture of Sarah on the back porch with her dogs. Because they allege that George Torres, in addition to abusing Sarah Boone, also abused their dogs. And used the abuse of the dogs to abuse Sarah. I personally haven't heard that. I don't know. I have to ask Tanika's 2 cents because she knows all the facts of this case to see if she's heard that before. Good morning, Marcus. Hello, hello, hello. Thanks for being here. So the judge wants the jury in now. The judge said the jury's been waiting for over an hour, which they have been. Let's get this show on the road. Already, it seems like opening statements by the defense, at least, is going to be a mess. I don't know what to say, y'all, but buckle up because I don't know. They just seem all over the place. They seem all over the place. A little scatterbrained, right?
Any reason why we cannot bring in our jury at this time? State.
No, sir.
Defense. All right, let's stand and bring in our panel.
Here we go. Bring them out. Bring them out. Thank you guys for being here. If you could you hit that like button, please? Maybe we can get some more people in here to ham it up with. Let's go back to Lou's statement about a concession stand would clean up in this courtroom. I agree. I already told you what I would want to see in my concession stand. Kettle corn, some Snickers. I'm trying to get more protein in, so maybe like grilled chicken kebabs. That would be great. Popcorn chicken, possibly. I don't know. It's a little
Morning,
too
y'all
much
may be
bread in
seated.
there, but let me know in the comments. What do you want as your snack and concession stand in the courtroom as we watch?
State, do you recognize our jury?
Yes, Your Honor.
Defense, do you recognize our jury?
Yeah.
Get the parties approach for a moment.
Are these the same people that you picked? We have confirmation. I just wonder what is going through Sarah Boone's mind right now. Is she regretting her decision not to take that plea? What do you guys think about the plea that she was offered? And the fact that she did
All right,
not.
members of our jury, good morning. I want to just
know that
confirm
well.
before we start this morning that you complied with the court's instructions last night to not have any conversations amongst yourselves or anyone else about the persons, places, things, or charge involved in this case. Then you have not conducted any independent investigation regarding those items. You just raise your hands to confer that you complied with the court's instructions. All right, the record will reflect that all jurors have raised their hands. Members of the jury, yesterday I told you that you may happen to see the lawyers in the courtroom or in the courthouse going about their affairs. And again, they're not trying to avoid you or speak to you because they're not allowed to. Did anyone happen to ride an elevator this morning with any of the attorneys, either for the state or for the defense? All right, juror in seat number 3 from my left, first row. Yes, ma'am. Okay, thank you. Can you all approach for a moment?
Oh boy. One of the jury members.
And a juror in seat 4, left to right, first row. Yes, sir. Who did you ride the elevator with? Do you recall who specifically, sir? Mr. Owens. Okay, thank you.
We got in the elevator with the attorneys, Mr. Owen specifically. Marie Jane says popcorn with extra butter. A spicy margarita, Butterfingers. Yes. You remember those commercials from back in the day with Bart Simpson? Don't lay a finger on my Butterfinger. Mm. They're probably discussing.
All right, thank you both for your honesty. I appreciate that. Something we
Okay.
talked about earlier this week. That's the one thing that we required and asked
Sharing
of you, is just be
numbers.
open and honest. And I appreciate both of y'all's open and honesty. During the ride in the elevator, was there anything that you saw or observed that it would impacted you or influenced you in any way, to have any impact on you? Juror number 3, left to right, first row. Juror number 4, left to right, first row. Okay, thank you. All right, with that, members of the jury, we're going to proceed with opening statements this morning. Both the state and the defense will have the opportunity to present them. I ask that you listen closely to those statements that they're going to provide. But remember, these are not evidence. This is just the party's belief as to what the facts and the evidence will show in this case. After the conclusion of the opening statements, we'll begin with the state's case in chief through witnesses. With that, Mr. Jay, you may proceed, sir.
Thank you.
There we go.
Ladies and gentlemen, what the evidence in this case is going to show you that this defendant,
We don't get a mic.
was able to do this because at the time of his death, he only weighed 103 pounds. She did this with malicious intent to punish him, and then she went up to sleep and left him to take his final breaths on this earth alone. How many breaths those were, we don't know. The evidence is going to show that it was at least for about 15 minutes that there's going to be PTO that the defendant herself took of this event. Evidence is going to show George Torres is dead because in this defendant's judgment, he served. Now, a conscious disregard for whether he lived or died, you will see here in the video. What I expect you will hear from a video that began
Oh, thank
at
you.
11:12 p.m., 45
Hold on.
seconds, on February 23rd, 2020, in Orange County, Florida, is a suitcase on the ground, face down, with the zippers facing the floor. You will hear Sarah, the defendant will say, "For everything you've done to me." Sarah, "For everything you've done to me." Sarah, "Fuck you." And then the defendant laughs. Sarah, "Fuck you." And the defendant laughs. Sarah, "Stupid." Sarah, "That's my name. Don't wear it out." Sarah, "I can't fucking breathe, baby. Seriously." "Yeah, that's what you do when you choke me." Sarah, Sarah, Sarah. The defendant laughs again. Sarah, "I can't breathe, babe." She laughs again. "That's on you." Sarah, "I can't breathe." She laughs again. Unintelligible words. And I would submit the evidence is going to show, because of the intoxication from alcohol, is the next thing she says. Sarah, 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 "I can't breathe, baby." "That's what I feel like when you cheat on me." Sarah, "Fuck you." "I can't fucking breathe, Sarah." "You should probably shut the fuck up." Sarah, "Shh," is the last thing you will hear the defendant say to Mr. Torres as he is face down, zipped shut, in a suitcase. That, again, began at 11:12:45 and lasts just over 2 minutes. At 11:23 and 3 seconds p.m., there's a second 22-second video, and it's the defendant zooming in on the suitcase. And all you hear during this 22 seconds, after he's been in this suitcase since at least 11:12 p.m., is one more time, Sarah. How did we get to this point where 103 pounds or short?
This is rough, guys. I don't have any better audio because they're not standing at the microphone.
Wakes up late morning, perhaps early afternoon, somewhere in this time range, several hours. And she goes downstairs, and she doesn't see or anywhere for it. Eventually realizes, oh, it's gone. The first thing she does after taking him out, and I think you will hear the description, but little lights out. And prior to the resuscitation, here's her claim that she presses down, he's on her chest, forcing her hair was trapped in her mouth. The next thing she does is call 911. Calls Brian. Brian, her ex-husband. They share a child in common. And this date, February 24th, 2020, is a Monday. Normal work day, most people. School day for their child that they share in common. But after they got divorced, the arrangement was they were co-parents. And that weekend included Friday, Saturday, Sunday. And Monday through Tuesdays, their child would be her responsibility. Wednesdays and Thursdays, their child would be his responsibility. So February 23rd, 2020 was a Sunday. Now he's led into Monday. Mr. Boone has been trying actually to contact the defendant several times that morning. Just wanted to confirm she was going to get their child after school. And there had been a history of reliability. So you will see in the phone record, calls her, and she finally calls her back. Being the nice co-parent that he is, comes over. Short drive. And then she's explaining to him what the heck is going on. He peeks into the front door of her townhouse, which allows you to view all the way to the back by your glass door. You're going to see that her kitchen is off to the right, and on the back side of the kitchen, right area. Also, some blue legs sticking out in view. Brian Boone says, check please. You need to call 911. He doesn't put set foot in that house. He does wait outside though. So now, after having first called her ex-husband, after having first waited for Brian Boone to come over, the defendant
I'm seeing if I can find a better feed, you guys.
what you will not hear are tears.
It's fine
You
when
will
he's
not
at the
hear
mic, but
sorrow.
he's not always there.
You will hear a certain level of concern. My boyfriend and I were playing last night. Put him in a suitcase, and we were playing hide and seek kind of thing. I fell asleep. Found him dead in the suitcase this morning. I don't know what happened. He had blood coming out of his mouth. Don't know if it was an aneurysm. Pulled him out of the suitcase, tried to give him CPR. He was in the suitcase and I fell asleep. He's not awake. He's purple. He's not breathing. There's some instructions about how to do CPR given to her, asking about whether an AED is available to shock his heart. It's too late. He's cold, he's stiff, he's purple. We were playing hide and seek. We were playing hide and seek. This is horrible. This is horrific what happened. Like, what happened? We were playing hide and seek last night and I fell asleep. She mentions that there was blood coming out of his mouth. What the doctor found was what they expect. He passed from positional asphyxiation, meaning like
Better.
an environmental suffocation. You don't have to have a plastic bag over your head, being shut with a full roll of duct tape, seal it off, and work your back in the face. Environmental suffocation. Close enough. You can't get the oxygen, CO2 is coming in and out of your environment. But you also did one porch trauma, torso, face, mouth. Should you work using low health first form, should you work like human trauma, low health for understand you all of that, you understand what but had all this additional trauma, and they trauma on the system. Now, Sheriff's Office, Orange County Fire Rescue show up. And interact with the first control officer. You see and hear that body on camera. More of the same as what we heard on the 911 call. I can see. Good. I fell asleep. What happened? A few hours later, the detectives from the homicide unit at the Orange County Sheriff's Office approach her, are ready to interview her after doing some initial things. Includes grabbing her cell phone, off of the counter that was found at the store, giving it to one of the bigger friends of the camera. Put your phone in the cloud. But it's time to give the first interview with the defendant. So they do the first interview with the defendant in one of their unmarked detective patrol cars there on the scene. And the basics of this remain the same, but there's a little more elaboration, as you would expect from trained detectives versus getting the 911 call taken.
Yeah, I checked too,
The
Marie.
basics of what the defendant tells them is we had wine, we
sorry
painted,
about
we
that.
drew, we did puzzles.
It's
The
hard for
particular
me to
wine
hear
we had
too.
was a Chardonnay from the Woodbridge winery. The bottles, plural, are in the trash. We started about 4 p.m. after Mr. Torres went to the store. Puzzles, art, listening to music, enjoying each other's company. We were just literally just enjoying one another's company. The other bottle of wine that was left over from Boer wasn't even half full. So the description she is saying is one bottle of wine and plus a fraction of a bottle of wine left over from the night before. Ladies and gentlemen, not all bottles of wine are made the same.
Not all bottles of wine are equal. He's right about that. There we go.
Bottles of wine that were recovered from the defendant's trash can were 1.5 liters, the equivalent of 2 standard bottles of wine. A 1.5 liter bottle of wine is 50 ounces.
Those are the big ones.
Given that a standard serving of wine is 5 ounces, you can begin to do the math. And there's receipts. The day before, Saturday, February 22nd, 2020, there is a receipt from Publix for a bottle of Woodbridge wine for $9.74. And then Sunday at 12:17 p.m., there is another receipt for $9.74 for a Woodbridge Chardonnay bottle of wine. And then at about 5:30 in the afternoon on February 23rd, again, there is another receipt for the same bottle of wine for the same price. And those two bottles of wine were recovered. They're going to be produced to you in evidence, and you will see that they are, in fact, Magnum bottles of wine. So that's the context that we're dealing with when we hear things like, we only had one bottle of wine, and we finished what was left in the bottle of wine from before. Well, ladies and gentlemen, there's two 1.5 liters that apparently were consumed by a 103-pound man and the defendant, who is in the same weight class.
That's a lot.
Plus, if you
Little
believe
people.
that the defendant and the decedent would leave leftover wine from any given day, any additional wine that was remaining from the 1.5 liters from Saturday. Ladies and gentlemen, that's a lot of wine. So in that context, we were just having wine, enjoying each other's company. At one point, we play hide and seek. She says she didn't zip it up all the way. There was enough room, in her words again, there was enough room for his little fingers to get out. We were still having a good time and whatever. And basically, you know, Mr. Torres is stressing out about jobs, his ex-wife, about money. And so they're just doing puzzles and doing things to keep his mind off of it. Doing art, playing with the dogs, dancing with the dogs, playing hide and seek. We were always trying to outdo each other where we could find each other the best. When they started playing hide and seek, she went up to the shower and then got tired of hanging out in the shower and came down, and that's when she found him playing around in the suitcase. We both thought it was funny. I'm going to zip you up. Two little fingers could stick out. And she went upstairs thinking, he'll get out, we're going to have sex and go to sleep and call it a day. It was a good day. She insists that they had wine, but we're not drunk. You will be able to assess that for yourselves when you hear the recording she made. No ill will between us last night. Last argument, maybe last week. Don't really argue. We came home, drink, smoke, did art, listen to music, play with the dogs. We drink what we can afford. We used to be able to afford liquor, but now we can only afford wine. And that's how that day
Cheap
ends
wine.
with the police. Goes and sleeps, stays at her ex-husband's house the night of February 24th. What they are doing, and by they I mean the Orange County Sheriff's Office, in part that's when they discover the two videos that I just described for you. And there's other things in the phone, which I will discuss with you in a little bit. But she's summoned in for another interview, and she sits down and gives another interview on February 25th, now Tuesday. She does describe past instances of violence. You're going to hear about that. She's going to say, Mr. Torres had hit her with a curtain rod about a month ago. Since then, though, like, we've been good. I've been good. She describes that he comes at her all the time. He comes at me. So it's either I flee or I try to go upstairs and go to sleep. That's usually what it is. I don't know if you talk to Brian, her husband, about any of that, but most of the time I flee and I go over there. There's a discussion about why she stays with him, and you'll hear that for yourself. She will say that she doesn't really want to drink. She just takes an occasional drink. She drinks to placate him, Mr. Torres. She says that you're going to see phone videos of Mr. Torres smashing her TV in the past, like a month earlier. You may see that too. But she doesn't get drunk. When she drinks, she likes being non-compos mentis, her words, not mine, having her wits about herself.
Who says that?
Then she gets to the hide and seek again and describes that they've played it 3 times before, but had never zipped one another shut in it before. And they were really just running out of places to hide because it's just a townhome. She does not remember, according to her, she does not remember taking any photos or videos of the night's events.
She was
At this
wasted.
point, they ask her, well, would you like to see it? And she says, I can't watch this. I flipped him over. I flipped him over, and that's where it was. Guys, this is killing me right now. That's why I flipped it over between the 2 videos. I didn't do anything intentional. Discussion over whether he had enough room to get any of his fingers out from the zipper. My intention was not to leave him there. We both got in there. Both of us were in there. When she went upstairs, my plan was not to, quote, he'll be up here any minute. My plan wasn't to leave him in the suitcase. Why is all this going on? It's the drinking. That's what it is. It's the drinking. I thought he was okay. Guys, that's how we were with each other. Nobody understands our relationship. This whole suitcase thing never happened before. Though she described it happened before. I'll never drink alcohol again. She insists that she has no injuries on her. And you don't have to take her word for it, because they took photographs of her and there were no injuries on her. She insists over and over that there was no violence that day. It's like, okay, we're in a good place right now. Ask her about saying fuck you to Mr. Torres. Well, that's just being playful and having a good day. Everybody's having a good day. I didn't touch him, nor did he touch me. Her words. What else is found on her phone? There's a conversation between Mr. Torres's brother, and again, nobody knows who's using these phones at the time text messages are sent in these records that you're going to see. But it's indicated that there's a communication between one of the decedent's brothers and the owner of the phone that was taken that belongs to Miss Boone. The text from the brother is, yo, my daughter told me what you did, Sarah. I don't want you around any of my daughters or nieces, nephews. And that's Christmas 2019, just under 2 months before this event. She replies, or the person using her device at this time, ugh, your quote-unquote dad hit me in the face. Next text is, hide and seek, I shall. January 13th, there's another heated discussion. She describes it on January 13th in a text to Mo, the brother again. It's a Torres thing. Boo. Sends a picture. Keep the fugly creep out too. It's still fugly. Lose. The brother responds, please do something with yourself, Sarah. God bless you. The defendant's response, and bless you and all of you too. I'll get, in all capitals, rid of him. Then it'll be, in all capitals, better. Ugh, Torres. Referring to Mr. Torres, getting rid of. And that's
Here we go again.
But we, the state of Florida, and the members of the jury, are adjourned.
Talking about Halloween and vampires and being invited in.
As we come inside this room, after beckoning, as we are going to point out, you're going to hear the first night the defendant met this evening, Torres smashes her phone, punches her. The first time in her life she ever been punched. Made her curl up in a fetal position on her own porch for 4 hours. She's only able to escape this situation and fell asleep. I expect that you're going to hear that Mr. Torres is an alcoholic. I expect you may hear his high score on his blood alcohol level is a 3.4. This is a man who has serious alcohol problems, and I expect you're going to hear about it. Despite that first date, and this is going to tie other things that I expect.
He's getting ahead of the defense's proposed statements that George was an alcoholic, that George beat her.
The things that come along with the relationship that make it harder to break off. It's one thing to have a bad first date. It's another thing to make it tough. Despite that first date, there's a second and a third. Now these days are at bars, and it just typically ends up she's going to tell you, I suspect, or you're going to hear what she says. It's one thing or the other. Like I asked the dude for a cigarette, or it flipped out, and I'm going to pay the price. Things like that. You're going to hear, potentially see, yes, there were injuries.
He's going into the different incidences of DV between the two of them. How when they first met, apparently George punched her in the face and smashed her phone.
Bloody ear. A stab wound in the leg. Perhaps described as sword fight lying around. But nonetheless, I suspect you're going to hear and see a lot about their past. And at the end of this verse, comes in, the state is going to have the opportunity to take the lead of the floor in this room, labeled the defendant and I guess the past history. I'm not going to go into that now. If this all comes to fruit, we bloom on the tree and discuss at the end of October. But I'm asking you to not rush to judgment. You hear all of the evidence and then apply whether or not these past instances have anything to do with what happened on those. Now, like the home inspector, there are experts come in and kind of help walk everybody through this room labeled the defendant and the victim's past relationship. I suspect there's a chance we may hear from some experts, psychologists and psychiatrists, about battered spouses.
I'm going to come back to this. I'm going to come back to this.
Things that we would hope that we pay attention to during all the testimony, if there is any, about the subject matter. One is that it's not actually a recognized diagnosis in the Bible that they use in mental health called DSM-5.
He's analogizing the DSM-5, which documents different mental uh, diagnoses as a recipe book.
Isolation, psychological violence, emotional violence, physical violence, sexual violence, which I suspect you would describe to you as well.
He's talking about uh, the mental effects of spousal abuse.
What it ties into at the end of the day, after you talk about the if there is a self-defense instruction, right? This is to help you understand what an objective and reasonable person in the circumstances would do. Because years ago, we've gotten better as a society. Years ago, when this was being researched, the question would be, well, why won't you leave? Back spouse syndrome, the testimony of experts help explain those things to people. Well, it's not that easy. You got to look at what's going on in the relationship, isolation, control, so on and so forth. That explains why. Now, returning to the facts of our case, what you're going to decide the facts are is ordinary, objective, reasonable person in those circumstances going to have to be self-defense. That's what it's used for. It's not used for explaining subjective reasons that one holds. But you will also hear about these things, just like any other time, or any expert, a home inspection. If a home inspector's report is based solely on the person trying to sell that house, what they say about the house, shape, I rewired the entire thing, brand new JDC pipes. This sucker's good to go. I did this. You're not going to take that home inspector's report, let's say, lift the hood, kick the tires, do all the things with the box under the car back today. You want an expert to get reliable information. An expert opinion only gets information from your source. They would say, yeah, you gotta take into account the credibility of the person who gives the report. The patient, the client, like saying all these things have to be discussed. You gotta find proper information. You have to check the reliability. Particularly circumstances that we expect. Another thing that they're going to tell you is just because there's a bunch of violent nonsense going on between two people doesn't mean that it's not something you want. Some people can go home and fight like cats and dogs.
Just because a lot of nonsense between the two people doesn't mean that battered spouse syndrome applies.
Just because you hear about those things, the experts doesn't mean that it necessarily applies. If this testimony comes in, I expect that Dr. Hartley said it applies. But we'll talk to her about what she relied upon to make that conclusion. Talk to us about it. But at the end of the day, after you hear all of the evidence in this case,
Thank you, Mr. J. Any opening remarks by the defense?
Judge, can we invoke the rule? It has been.
I've already advised the witnesses.
Okay, the rule of sequestration will be invoked. Thank you.
We're not going to hear anything he says. Oh,
You may proceed, sir.
this is real frustrating, guys. Let me switch to Trial TV Live and see if this may be any better.
Sarah Boone and George Torres. Between Sarah Boone and George Torres. Sarah Boone and George Torres
Just better?
were down and out,
A little bit.
as you can be, around alcohol.
We don't have captions because I switched the feed, but I think
Both of them
they're a little better,
suffered
right?
from, used to be called alcoholism, now it's called alcohol abuse syndrome. And so day to day, they struggle with the use of alcohol. You can imagine that. It affected their jobs. It affected keeping employment. It affected even getting a job. As codependent as you can be towards each other. And you're going to learn with all that was domestic violence. And that George Torres physically abused Sarah Boone. And she suffered from the effects, the psychological effects that one suffers from
Thanks for hanging in
repeat
there.
violence from an intimate partner. They were together over 3 years. And there were several prior incidences of violence. We've got the photographs. There were incidences. We took photographs. So you're going to be able to see the evidence. And we believe the court will instruct you at the end when you're considering self-defense, which we call justifiable use of non-deadly force or justifiable use of deadly force, that you can consider the prior acts, the history of violence, the prior difficulties that the parties had. And considering her set of circumstances that she was faced with in making the decision to use reasonable force under the circumstances. And the most important thing I can tell you here today is keep an open mind. There's two sides to every story. You're going to hear the state's side, them attempting to paint her a certain way, as they've done here today in opening statements. And then you're going to hear another side. And you're going to have to weigh that. All the evidence, the credibility of the witnesses, the photographs, the videotapes, and come to a conclusion. let's talk about this day, February 23rd of 2020, the day
Oh, come on.
of this opinion for some time. Here we are, October of 2024. I think the evidence is going to show that they had purchased some wine the day before, but they hadn't finished all of that. So it was in the refrigerator. Many times that's how they start their day. At some point, you're going to see a video from Publix, from where they live. I believe it's Winter Park. But Publix was not too far from their apartment complex. And they took their car, they drove over there. So you're going to see a videotape from Publix of them both going in the store about noon, and they come out with one of those larger bottles of the wine. And then, of course, there's a receipt, and the bottles are in the garbage can. Of course, between the two.
This is bad.
And as everybody knows, couples can have great times where things click, everybody gets along, and then we can have episodes.
Hi, hey, Mona. Good morning.
And how are those resolved? Really, is what this is about. How are disagreements resolved? But George was very jealous of Sarah. You're going to hear the testimony about that. And that he cannot, in certain situations, he can be very charming. But when his level of intoxication gets to a certain level, is when he gets sad.
I have another feed that I want to try.
And
If I can
and
get
a lot
like
of
a
times,
break,
eventually, it involves
switch to it.
forcible sex with Sarah Boone or actual physical violence against her. They bought the wine. It's a simple life. They don't have much money, but they both like art. They did that for a while. They both like puzzles. They did that for a while. Well, about 5 or so, the wine bottle was gone. And George had said, I want to go get some cigarettes. So there's a convenience store right close by their apartment complex. And Sarah thought he was just going to walk over there and get cigarettes and come back. But no, what he did was he got her keys, he got her debit card. And he went over to the Publix and he got another bottle. And I think that was about 5:30, something like that. And again, there'll be the Publix video showing him going in, going out, and there'll be a receipt for the purchase of that bottle, and then they'll keep that bottle. It will be in the garbage can along with the other bottle. Well, when he comes in with the second bottle, Sarah knows. This is not good. She knows this means he's going to get to another level of intoxication. So Sarah's concerned. So she attempts to placate him, keep him busy, keep him in a good mood. They drink that bottle, but she drinks as well. And at some point, they're intoxicated at a high level. As some people do when they're drunk, they get silly. And they decide to play a game of hide and seek. She goes upstairs, their bedroom's upstairs, to the shower and waits for a period of time. And he doesn't come to her. At some point, she gets cold, she gets tired. She wants to go see, well, maybe we got it mixed up. Where is he? So she goes downstairs, and they had gotten a suitcase down a week or so ago. It's an old suitcase that they were going to donate to Helping Hands or Goodwill or somebody, and they were putting some items in there. And it's a broken down suitcase. It's a large suitcase. They both weigh about 100 pounds. And they don't eat good. malnourished to a large degree. But the pull handle is broken off. And they've attached a little paper clip that's got the rubber around it, and that's how they tie it. Well, she comes down the steps, she sees him getting in and settling in the suitcase. So she walks over there, and they see each other, they smile and laugh, and she zips him up. And she zips him up, and they laugh for a while. And they carry on. She sits on the couch. And at some point, he says, "I can't breathe." Now, his face is facing the zipper, and she's got 2 or 3 inches that she's opened it. And she doesn't know. They're intoxicated. She doesn't know whether he's just saying that to try to get her to get him out or what. But he's a captive audience. Physically, they're the same size, but he's much stronger than her. If they got in a fist fight, he would win 100 times out of 100. But she's got him now. He claims he can't get up. He has to sit and listen. Physical restraint. And so she lets him have it. Says things she shouldn't say. It's about 2 minutes long. She videotapes it. She sits on the couch and turns her phone on and videotapes it for about 2 minutes.
Oh, this is jumping.
There's another video that's approximately 11 minutes later. The first video, George's, the suitcase is flipped upside down. The zipper is flipped off. 11 minutes later, Sarah has flipped it right side up. Again, open for him to get out. And it's only 22 seconds. And you hear George say, "Sarah." And that's it. Now, the key to the case is that 11 minutes. And what happened during that 11 minutes. Okay?
Is that? All right, you guys, I'm going to switch over. This one is jumping too much for my liking.
And they took their car, they drove over there. So you're going to see a videotape from Publix of them both going in the store about noon.
I'm going to back it up just a little bit.
It's about 2 minutes long. She videotapes it. She sits on the couch and turns her phone on and videotapes it for about 2 minutes. There's another video that's approximately 11 minutes later. The first video, George's, the suitcase is flipped upside down. The zipper's on the bottom. 11 minutes later, Sarah has flipped it right side up. Again, open for him to get out.
Be better.
And it's only 22 seconds. And you hear George say, "Sarah." And that's it. Now, the key to the case is that 11 minutes. And what happened during that 11 minutes. Okay? That is the key to this case. Sarah Boone will take the stand. She will explain what happened.
So she's definitely testifying.
She will explain why it happened.
She has to.
The evidence will show that she was justified in the action she took to prevent an attack from George Torrance, which the law acknowledges that every one of us has a right to invoke, the right of self-defense.
Are you going to tell us why she was justified? Or maybe that gets into his prior acts. So he's not allowed to.
You can hear from the medical examiner.
Yeah.
She is going to tell you about some bruising on George Torres. Of course, he was in the suitcase a while, deceased, we believe. And that changes things a little bit, as the medical examiner will explain, but there's some bruising. Sarah's going to explain that to you, why that happened, what were the circumstances surrounding that, involving that. Her son comes and stays with him from time to time. He has his own room. He has several of his things there, and there's a bat downstairs. The same bat that George Torres used, and there's a video where George is threatening Sarah. And he's swinging the bat at the TV about as hard as he can. And he does it about 6 or 7 times. You'll see it. Sarah's recording it. And it's during an argument. And he's trying to intimidate her. Sarah loves you. You know, you're going to hear why women don't leave. Why women don't leave. And you're going to hear about Sarah Boone and her struggles, her mental health struggle. Sarah had no intent to kill him. The prosecutor mentioned she wanted him to die. Farthest from the truth. She loved the man. She hated the abuse. She couldn't leave him. She tried. She tried kicking him out 6 or 7 times. He kept coming back. She changed the locks. He kept coming back. She didn't have the family. She didn't have the support. She was weak, vulnerable. You're going to hear it all. You've got to take that all into account to try to understand what happened and the circumstances surrounding this tumultuous relationship. Now, you're going to find that Sarah's not perfect. And, you know, she goes, as many of us do when we drink too much, and you sleep in. She slept in. 11, 12, 1, somewhere around there. She moseys downstairs looking for George. She thought he was on the computer looking for a job. She looked outside, maybe he's out smoking a cigarette, and she sees a suitcase. She unzips it. She gets him out. He's purple. She tries her best to do some CPR. She freaks out. The only family she's got is her ex-husband. Really. She relies on him. As the prosecutor said, a lot of times she'll flee to her ex-husband's house. And where her son is at. Lucas. It's the only thing she knows to do. She's kind of a sheltered daughter when she was younger. She's smart, but she's not worldly. She calls Brian. What do I do? He said, I'm coming over. Please come over. He's about 5 minutes away. And she calls him again within a couple of minutes. Yeah, I'm on the way. He gets there. He walks in the foyer and sees his legs. And she called 911. She calls 911 within a minute or two. Detective Rodriguez arrives. You know, they got the body cam now, so it's recorded. So you're going to hear Sarah talking. But Sarah's freaking out. Sarah's thinking, and I'm somehow responsible. Eventually, she gives a statement to law enforcement. She gives one to Detective or Deputy Rodriguez. Of course, she's not the homicide investigator. She's just responding. She's the first responder. And, you know, they know what to do. They try to assess the situation. They start putting the tape out. And then they call for the homicide investigators to come, which takes a little time. So she gets a statement from Sarah. Eventually, the homicide detectives get a statement from Sarah and one of the unmarked squad cars. And it's recorded. You may hear that. And then the next day, they take Sarah's phone. Sarah gives them the phone, signs the consent to take the phone, take it to, they have a phone extraction people at the sheriff's department where they can take it and take out all the data, all your phone calls, text messages, photographs, videos, all that. And they find these two videos. Sarah's not aware, she doesn't remember making the video. You can imagine. She gives them the phone. Of course, she makes no attempts to do anything other than, here's the phone. So they tell her, you're going to get your phone back tomorrow. We'll bring it back to you tomorrow. Well, they end up having a conversation with the female detective, homicide detective, Hobson, is her name, Chelsea Hobson. And they end up, Deputy Hobson was pregnant, or Detective Hobson was pregnant. They said, hey, we're not going to bring your phone. I'm not feeling good, pregnant. Can you come to the sheriff's department? Which Sarah Boone was telling you that was what I was going. That's what they told me I was going to the sheriff's department for. Well, instead, it was an interrogation. And they were going to arrest her. They made their mind up on it. And they were going to confront her and try to get her to confess based on the two videos. And so there's approximately a 2-hour interrogation that was on the 25th in the afternoon when she got there to get her phone. They said, well, we got to come up here. We need to talk. And they got her in the room. It's a small room, but it's being videotaped and audio taped. And it goes on for about 2 hours of them trying to get a confession to murder. And it doesn't happen. But Sarah lies. She's scared. She can tell they're trying to pin her on this, that this was some kind of intentional act, and it was not. So she lies. She's not a lawyer. She doesn't know about self-defense. She doesn't understand she has a lawful right to defend herself. She doesn't understand that she's justified in using the force that she used. She doesn't. I wasn't there to advise her. No lawyer was there. So she lied. And you're going to hear that. So you're going to have to balance that versus her taking a stand and testifying before you. And we simply ask that you look for the evidence of cooperation of her testimony. It's going to be later, probably next week. The judges will tell you in reading instruction on evaluating the witness's credibility. And they'll talk about corroborative evidence, other evidence that's consistent with the testimony that Sarah Boone gave. So you're going to have to weigh that in her testimony. Now, self-defense, we talked about it in jury selection, usually a gun, some deadly weapon. The suitcase in this case was a physical restraint or a blocking of an attack, but it was unconventional. Self-defense nonetheless. Now, as I said, the struggles that occurred, many of them involved police. So you're going to actually hear from some of the police officers. Maybe some body cam footage. You're going to see some photographs that they took of the injuries to Sarah Boone. And some of the videos you may see of her in a very happy, joyful type of thing. Well, number one, she's intoxicated. Number two, she's safe. Police are good.
Happy
So
girl.
her attitude is not one of distress. We're here today, full packed courtroom. Judge credits here, but you're the most important people. Because you've got to decide this case honestly, fairly, and according to the law. And we talked about the two biggest principles from the Constitution that apply. In this case, and in every case in which a citizen like Sarah Boone is brought into a courtroom and accused of a crime. The first is, you as a juror must presume or believe that Sarah is innocent. And that belief stays with you throughout the entire trial. Because of that, she doesn't have to prove anything. That's why the state went first in jury selection. That's why the state went first today. That's why the state will go first putting on their case. They have the burden of proof, and it's the highest burden we recognize in any type of litigation in this country. Proof beyond and to the exclusion of every reasonable doubt. You are going to have doubts about this case. But the most important thing is not to rush to judgment, to keep an open mind, and understand there's two sides to this case. There's their side and there's our side. So you can't form any fixed opinions early on. That's hard to do, as Mr. Henderson said in jury selection. That's extremely hard to do. Now you're going to hear some testimony. There's been mention of experts. Battered women's experiences affect her perception of imminent danger. Battered women's experiences affect her perception of imminent danger. Victims of repeat violence may fear death in a situation others would not. After hearing both sides of this case, we're confident you're going to have a reasonable doubt. And we're going to ask you to follow the law and do justice in this case. And find Sarah Boone not guilty, because it's the right thing to do. Thank you.
Oof.
Thank you, sir.
Wow.
Can the parties approach for a moment?
Wow, you guys.
We've been listening to opening arguments in the Suitcase murder trial.
All right. So that's it. That was the openings. And I think that's probably all that I'm going to stream for you guys today. I have some work to do and some things to get done. I will be watching what goes on in the trial the rest of the time, but not closely enough to stream with you guys. Thank you so much for joining me. Let me get to the questions really quick before we go. Lou, I don't know if you're still here. Thanks for joining if you are. Hey, Misha, do you think it stands to reason that the defense would also imply Boone's son was mistreated by George? I have not heard that implication before. I haven't heard that accusation before. I don't think that's a thing that has come up. What I have heard is that the two, the son and George, got along very well and that they played with each other and that they enjoyed each other's company. But I have not heard any implication of abuse of that son by George. Like we heard in the opening that George apparently, no, we didn't hear that in the opening. We heard that in the hearing before the opening, an implication that George Torres also abused the dogs, which is as unconscionable as abusing Sarah herself. But, you know, it seemed to be a reciprocal abuse, which is never good. It's just that cycle. But to answer your question, Lou, no. Marie James is asking, is Boone using the battered wife defense? Yes, yes, she is. It's called the battered spouse syndrome. And it'll be interesting because the defense expert who they got statements from and deposed before trial started apparently was asked if there was an overt act that caused fear in Sarah, a reasonable fear in Sarah, such that she would need to resort to use of deadly force. And the expert was unable to pinpoint or name any overt act, and that is a predicate to using the battered spouse syndrome. So what the judge said basically is that no no evidence about battered spouse syndrome will be allowed to be presented to the jury unless and until Sarah Boone herself testifies and gives some explanation of an overt act, because that is necessarily a predicate. And if we just start talking about it and bringing in evidence of a battered spouse syndrome, unless there's an overt act, there's no point in raising that, in talking about it, in exposing the jury to the possibility of that having happened. And if you expose them to it, to the fact that it's a relevant defense, and it's not without an overt act, you can't unring that bell. You can't unring that bell. And some of the evidence that the defense wants to bring in to substantiate the overt act resulting in her fear are the past incidences of domestic violence in the home between George and Sarah. So that's all we have for today. Let me see. I don't think there are any questions, but I just want to thank you guys for joining me and watching these openings. Let me just look back really quickly to see if they started doing anything else. Oh, no. All right, guys. So this looks like the first witness is on the stand. I'd like to suggest a feed to go to, but honestly, I don't know one. Let me see who else is streaming this live. You could go to Emily D. Baker, but she has thousands of people in there already. You should go to somebody who is smaller, and you have a chance of your comments being read on screen. How about Lori Reese, Lauriereece? She's streaming. Also, Corgisaan, Corgisaan. Apparently, there's some way to redirect people, but I don't know about all of that. So, anyway, thank you guys. I appreciate you. Oh, Marcus, I didn't even see that you wanted rotisserie chicken in your concession stand in the courtroom. I hope you get some rotisserie chicken this weekend. Have a good weekend, you guys. I'll talk to you later, and we'll touch base on this case. All right. Bye.